Welcome, viewer, wherever you are. This is the Cardinal Talk show, a show that comes to you every single Sunday at a time like this, where we talk about matters that actually made political headlines in the week. As usual, this is a moment for you to sit down and then begin reflecting what actually happened. And as you reflect on that, we'll be engaging panelists here who will be giving us more information about just what happened. Yes, from what we saw, like it was the coronation of Justin Muturi, the speaker, as the spokesman of Mount Kenya, to what must have been an aborted exercise. Now it's becoming even murkier. Confusion is reigning in the mountain, and actually what is just happening. Before we even go further, this was a week of prayers, and it was so nice. Don't forget, it was a week of so much activity at the Court of Appeal. Everybody wanting to appeal rulings of the High Court, and that is why Wakili Paul Aol is with us here and will be giving us so much information about this. Gentlemen, welcome to the show. How has it been? How has your week been? And generally, just how are things?
Thank you, Nick. Thank you for having me.
Yeah.
My week has generally.
I think you give us your name first.
Oh, my name is.
Are you forgetting your name?
Sorry about that. My name is Gitonga Latanga, businessman and political activist, and a member for a life member of ODM.
You're still a life member of ODM?
Yes, I am. I've not yet been expired.
You
and I've not withdrawn my.
You not withdrawn your candidacy. I mean, you have your membership.
My membership, yes.
Is it possible to withdraw a life membership?
Oh, sure, yeah.
It's possible.
Yeah, it is. It's just a member. It's only a category.
It's a category membership.
Yeah.
Thank you very much.
Membership.
On my left is a renowned lawyer, Wakili. It's your time, perhaps just and your name. You're not a very new face. That's like it is not a new face. However, there are people watching you today for the first time for their benefits.
My name is Paul Aol, a practicing advocate based in Nairobi. I'm happy to join you.
Thank you very much. Gentlemen, this week has been momentous, and just to say the least, it's a week that has seen serious appeals to the Court of Appeal. People want to appeal the rulings that were so many. Some of them actually dealt a blow, complete blow, to any possibility of BBI resurrecting. Some even said that this is supposed to be one of the monumental judgments that will be used in years to come as a case study for upcoming lawyers and even practitioners of the law in future. I just don't know why. If I begin from your perspective as a lawyer, why did this ruling actually have that kind of understanding where lawyers, advocates, experts looked at it like a monumental ruling that is supposed to be used as a case study, even in schools, even for future law scholars, even for practicing lawyers, and even judges who sit in the bench or on the benches. They're saying this ruling is actually a complete ruling. I don't know what it means.
Thank you again once, Nick. The main reason why this BBI ruling is called monumental is because so many issues were raised. Some relating to processes, some relating to the presidency, what he can do, what he cannot do, some relating to what you call the sovereignty, or who are the people, what can you do, what can you not do, and others even relating to processes like referendum, quorum of IBC, amending the constitution. So some of these issues that have been dealt with in this case have not been dealt before. For example, this ruling dealt with the issue of, can somebody who is elected, who has a forum through which he can address his issues, can he also come back again and say that he's Wanjiku? For example, if you are an elected governor, if you are an elected MP, if you are an elected MCA, can you come back? Is it the intention of the framers of the Constitution that you can come back and act as Wanjiku and drive the popular initiative? This ruling has also dealt with issues like the presidential power. Can president appoint certain people to champion certain issues? Can president, as the head of the nation, can he drive agendas through certain processes? So yes, this ruling has, and even why there are so many appeals is that some of those issues that it has raised, if these individuals don't or these agencies don't appeal, then it might affect their work for a very long time, or it might open a Pandora's box that can affect their work, or they can begin having legal challenges that can begin coming their way. For example, it raises the issue of quorum with the IBC about their work, where it defines that there are certain things that are administrative in nature, that they need certain numbers. There are certain things that are policy in nature, that they need certain numbers. And also, if it goes into where it even says that certain presidential actions are unconstitutional, if the president does not appeal, then technically somebody can go and say you've engaged in something unconstitutional. Kenyan public money cannot be spent in something that is unconstitutional, or you violated the articles in Chapter 6, and as such you're supposed to be impeached. So yes, it dealt with so many issues. The court gave their understanding of so many issues and how they think things should be done. So that's why it's monumental, and that's why I advise that anybody who's not had the opportunity to read it, need to read it. It will help them understand how the court understands so many things about the Constitution. The ruling even dealt with the issue of that even if you want to amend the Constitution, there is a process that is unconstitutional in the process of amending the Constitution. Yeah, the court even introduced the whole concept, which has not been dealt with in the Kenyan jurisprudence, something called the basic structure doctrine, where you're told that fine, even if you follow the law to amend the Constitution, there are certain articles within the Constitution that you cannot amend.
They are unamendable.
They are unamendable. For example, the court is trying to say that, can you say that even if you follow the right process, can you come and say that you want to collapse the whole arm of government? Like you want to say that you want to get rid of the judiciary, or you want to get rid of parliament, or you want to get rid of the executive. So this is why the reading is important to every Kenyan, so that they get to know how the court thinks, and where the court tells you that even if you have the numbers, even if you follow the procedures, you need to know there are certain aspects or certain articles in this Constitution that should be there for life.
Well, I'll come back to you about basic structures of the basic structure of the Constitution. Actually, it's a new terminology that is gaining serious momentum with the people, perhaps people who know the law, and even people who don't know the law. But it came into our understanding that there's something called the basic structure of the law, the foundation of that Constitution, which must not be interfered with. A very interesting part of that ruling. However, I want to bring you in as a politician now. And well, you can also delve into matters that you think you can shed light on in terms of what the ruling had. However, from a political point of view, this thing seemed to have suffered in the hands of the legal process. Under the politicians, the political body is like trying to still kick. They're still kicking, trying to shake a little bit. Is it something that, in your opinion, as a politician, has given rise to particular knowledge, understanding, and lessons that we've gotten here?
Before I respond to that, you mentioned about the basic
structure.
The basic structure.
Okay, you want to talk about it then?
Yeah, let me mention something about it. There is the problem in that ruling, because that basic structure is not defined in the Constitution. So the question is, who are the courts to determine the basic structure? Do 5 judges sit somewhere and decide these are the basic structures? These are the Constitution itself has provided the way to amend the Constitution, and there is no article, okay, that the Constitution provides cannot be amended. Okay, that provision is there. So for the judges, I think they overreached themselves to come up and decide which are the basic structures. Because now, then they have this one as their basic structure. Another panel of judges who also decide which their different basic structure. Mm-hmm. So it's it creates confusion, and I think in that way that ruling there, I think is it's very appealable. It's
appealable in your view.
Yes. Ideally, as Wakili says, of course there are articles or there are structures that we cannot really change as per se. Yeah? But does it mean the Constitution? The Constitution does not prohibit. If we decide today as Kenyans we don't want the judiciary, and we go and the Constitution does not prohibit that. That you cannot say that we cannot amend that. We can. It provides for that.
So there's no section of this Constitution that is unamendable.
No, as far as the Constitution is concerned, all right. As far as the Constitution is concerned, all articles are amendable.
They are amendable.
Yes. Other considerations, if you look at maybe social considerations or political considerations, yes, maybe they are not. You can say we cannot amend because of political considerations or social considerations. Yeah. But as far as the Constitution is concerned, I think all articles are amendable. Okay.
Yeah, Wakili, I'll bring you into that because you say it's not possible. And Mr. Gitonga Walanga, as a politician, looking at the whole fabric of this ruling and looking at the political activities that actually ensued before this ruling, is it a point where we now realize as Kenyans that every political move must actually breathe some sense of, some sense of due diligence before it's undertaken? Ideally, they could say even the process of signature collection is something that, in their opinion, is unlawful. But as a politician, you people went out there, talked to people, and you call it public participation, and that is why you ordered guys to go and do that signing because of what you feel you had done in terms of public participation. Kindly narrate this.
Nick, remember last time we were here, we actually we delved into that a bit, and especially as concerns the issue of the limitation of boundaries by IBC. Yeah. And the question is, why do you think? Why did the Secretariat or the proposers of the bill, why did they allocate constituencies to particular areas? Well, they don't know that requirement of Article 8, I think 4C. That is the role of IBC, and we said it's sheer it's impunity. It's impunity because I don't think that those people are that ignorant. Of course, they have they had their resource persons who are well versed in the legal matters. But ideally, when we talk about things like public participation, there is a limit to how much participation can be done, and you cannot really satisfy everyone. But what the judges, I think what the judges were suggesting, I don't think is really realistic. It's realistic. But whatever you have been doing, going to rallies and what have you, it is engaging the public. It's involving the public. It's really public participation. Yeah.
But the judges seem to have poured cold water on that. That all the rallies, the reggae rallies that were going around were not people participating in them. It was politicians actually going there to pronounce to them, to read to them what is expected of it.
Yes, it's politicians because this is need driven. It's a popular initiative. It's people driven. It's a popular initiative, and it's of course the people to enlighten the proposers. They are the ones to enlighten the masses on. I think on the bill. I don't think it's the issue of. I don't think that is the responsibility of say IEBC. I think it was public participation. I think it was supposed to be carried out or be pushed by the proposers. And I'm not sure.
Of course, even in Parliament, if you come up with a bill in Parliament, you'll always move the bill, the motion as them. It's like now the politicians actually the motion movers in the court. In the Parliament of people, of persons.
Yes.
Yeah, I think that makes sense. However, before we go far, I want to bring in Wakili in this matter of basic structure again. Gitonga says there is no way we can define a basic structure of a constitution, and what becomes a basic structure in this ruling might perhaps change and become another basic structure in another ruling. Don't we have a standard measure of what is supposed to be a basic structure of a constitution, or what is it as a lawyer? Because we don't know.
As a lawyer, the whole concept of basic structure is based on common sense, to be more honest.
Common sense?
Yeah, it's based.
There's nothing in law, only common sense.
No. It's where it came from, where there's the understanding that there's something called a basic structure in the Constitution. Mm-hmm. It tries to embody the history. It tries to embody the whole concept of basic structure is simple. It's trying to appeal to your common sense. For example, it tries to tell you that in as much as you can say and argue the way Gitonga is arguing, that everything can be amended. Can you really go to the Constitution and you say you want to do away with all the security agencies and you strike them off and you say we've amended to do away with the whole chapter that deals with the security structures? Or that you are tired of the judiciary and as such you've amended and the whole chapter that deals with the judiciary is no longer there, and as such Kenya can now exist without a judiciary. You understand where I'm coming from? Mm-hmm. So the whole basic structure is trying to say that even in as much as you can argue, in as much as you can amend things, it is important to agree that there are certain things that should not be amended. There are certain things that you cannot do away with. Because once you do away with them, then you've moved or you've removed life from that constitution. For example, and there are certain things, because in that ruling they overtried. For example, something like presidential term limit. You know where we've all come from, it's a matter of history. Should we go and say that now we want to remove the presidential term limit? Because we have the numbers. Yeah. Yes. So the basic structure doctrine is just trying to say that in as much as you're trying to amend, it can even be constitutional and you can follow the right procedure. But what you're doing is unconstitutional because life cannot move that way. You cannot go and say that fine, now we don't have judiciary. You cannot go and say now we don't have the police force and any security agencies. You cannot go and say that now you can even regulate. There are certain things, like for example, and I'll tell you, because it's an argument that is more academic than, and that's why they've never listed, and I agree with Gitonga, they've never listed that it's this article, this article, this article, because it's academic. It tries to appeal to your common sense. It tries to make you see sense of why certain things should not be. Like for example, because it's even been done in other areas, where you find, for example, parliamentarians get tired of a constitutional commission. Like parliamentarians go and say, we are tired of EACC. They want to look so much into the CDF and the things we are doing. So can we decide, because the work of passing the budget is our work, we only give them 1 million. They survive within 1 million for a whole financial year. You understand? So the basic structure is actually trying to tell you that there are certain things that you can't do. In as much as you can say that the law is with me, it is still unconstitutional to do such things. That you cannot put even a constitutional commission and give it a budget where it cannot even operate. Like you even say that, okay, fine, we are tired with IBC, you'll only have one commissioner. Yes, they can amend. But now the basic structure is trying to tell you there is a limit to which you can go. If you go beyond there, then now it is unconstitutional. And now this basic structure is saying let's first agree, even without mentioning the articles, that there are certain things that are basic in this constitution that should never be touched.
Mr. Kitonga, it keeps getting even more complicated as we discuss into this, and where now it has to summon every person's understanding and common sense, then it's open for any amount of abuse you can imagine. My thinking or my question would be, do you think the 40-something million Kenyans would summon their intelligence to work and then reason like Okello is reasoning, such that a basic structure makes sense to them?
Definitely, these are definitely not. These are legal. They are legal issues. And, they are legal issues, and the constitution, as Wakili says, it's not. Understanding is not direct. It's not something that you can read and then just understand it. Of course, you've got to have a good,
background,
a good background, such that you are also able to relate with other issues, and but that's why we have leaders. Okay, that's why we have leaders, such that, and we have political parties, such that now, for instance, now on BBI, say like ODM had taken a stand. They had said this document is okay. We have gone through it. They have their legal experts who have gone through it and have understood. And since we belong to that membership, we are advised by our party. This is document, we want it, and we urge you to pass. Okay, we urge you to vote for it. Yeah, so Kenyans as individuals, they don't necessarily have to understand what is in those BBI, in the BBI amendment.
The details and all that.
No, they don't, and of course we don't. A lot of us we don't. And even if we were to read it, I have heard people claiming, yeah, you give us copies. Even if people are given copies and they read, they can hardly understand. So in fact, it's a waste of time printing copies. And if anything, they won't even read. They won't even read. And those who read, they won't even understand.
Is that what your party is taking to the Court of Appeal? Because what you're saying is actually what I see people trying to reason around here, that Kenyans, even if you give them the copies, they would not read. The leaders have read it, and it's not possible to give all Kenyans copies.
Yes, even if they were to be given copies, believe you me, they wouldn't even understand. These are legal issues. So you see now, even if we had read it, how would you have understood
the interpretation
or the basic structure? Would you have known anything about the basic structure?
No.
So ideally, and that is why we have political parties.
Yeah.
That's why you have political parties, because political parties are supposed now to gather the resources, and then they understand, they can use whatever issue is at hand, and then they advise their members accordingly. That this document, this amendment bill, have gone through it. It's good for us. It's good for the country, and let's support it. All right, and that's good enough. That's good enough. But the court expecting that we'll hold barazas in every I don't know, in every
village somewhere.
In every village. Who will do that? Where do we get the resources from?
It's not possible.
It is not possible. And the problem with this country is, if you bring a group of people together, okay, I don't know, civic education, you have to facilitate them. All right. Other than getting the premises, you have to buy them lunch. You have to get them lunch. You have to give them.
So it's in terms of cost, it's not possible.
It is not possible. It's not practical. It's not practical. The kind of they are talking about civic education. It's really not possible.
So, in your opinion, you feel that was a far more isolated case to be even adjudicated by the courts?
Yeah, of course, yeah. And I think that, as I said before, I think they overreached themselves. They were looking, I think, for excuses. They were looking for as many excuses, at least, to throw out BPI.
One of the excuses of their ruling, my friend.
Yeah, they are looking. Okay, because look at this. Look at some of the rulings they made. They contradicted what the High Court of the same court had ruled on. For instance, now they consider the composition of IBC. Somebody had gone to court to challenge when this when they resigned, when the commission resigned, someone went to court. And the court then ruled that the 3 commissioners, they're okay, the constitution is a good quorum. Because actually Article 250 of the Constitution provides that every commission shall have at least 3 commissioners.
Is it 5 or 3?
3. Article
Is it 5 or 3?
It's 3. It's 3. Yeah. That's Article 250, Section 4, I think. 250, it requires that each commission have at least, and that is what the High Court relied on. But these judges relied on an act, I think, an act of parliament.
Which is subordinate to the Constitution.
It's subordinate to the Constitution. The other one was that Nani had wrote on. There was another thing that it's about the task force, the BBI task force. Somebody had gone to court, and I think, what was it? I think that way around. Yes, and it was ruled upon, and the High Court ruled that there's nothing wrong with the task force. There's nothing wrong. But these judges of the same, the court is of the same level, and then they rule otherwise. It's a contradictory.
So it comes out as an alarming judgment that perhaps was necessitated by something else other than what is supposed to be jurisprudence.
Yes, it is very contestable in my view. It's very contestable. The only area that I have issues that in my view that they have difficult in contesting is that one of the limitation of
boundaries.
Of boundaries.
Yeah, which is supposed to be a prerogative of the IBC.
I don't know that one. I don't know how they go about it. But this issue of can a state officer, a president, or an MP be a Wajiko, and he's a state officer. I think it's also contestable because even the president, when he becomes the president, his rights as a Kenyan, none of them are withdrawn.
They remain intact.
They remain intact as a citizen of his rights and obligations as a citizen of this country.
So he's Wanjiko.
He is Wajiko because the Constitution also says a citizen of this country can
run as a president.
Can start a popular initiative. So the president, the president, being the president, still has got that. What happens when he becomes president is that he's got options. He's got 2 options. All right, he can be that one of a citizen is still there, but then he has got the option of going through the executive,
and legislative.
Yes, going through the registration. But I don't think it denies him the right as a citizen.
Wakili, well said. It's so interesting. These are legal jargon sometimes. There are things like stay order, a lot of things that we've been treated to. Some of them, if you ask Wanjiko, like he says, are things that are flying in their ears and getting off from the other end. And it's so difficult to understand. Is this thing appealable? We are coming after a short break. I just want that line. Is it appealable? Is it that the proponents of BBI are seeing some light at the end of the tunnel? Are we going to see an appellate, the Court of Appeal that would give a more understanding and in-depth interpretation of this ruling of the High Court? When we come back, perhaps you can just give us an overview, because we are not permitted to speak about what is in court. However, it's just good to look at what is supposed to be, what is supposed to be appealable or what's not, and then we give now what's supposed to be now a summary of whether it's possible or not. So, viewer, don't go away. This show goes on immediately after this break. As you've heard, it is legal meandering, legal technical jargons, and everything that sometimes leave Kenyans even more confused than they were before. But then, that is what we call now professionalism. Let's give it to them. Let's wait until they do it. However, Wanjiko is waiting out there for the outcome, because Wanjiko ultimately has the say. Yes, viewer, if you are joining us right now, Welcome to the Cardinal Talk Show. Today, again, we are delving into matters that that is now being referred to as a monumental judgment by the High Court over BBI. However, we are going down to nitty-gritties to just see how possible is the ruling appealable in that Court of Appeal, which right now I know everybody is waiting to see how its constitution is gonna be, and then we also see what the ruling will be. However, there's also the factor of timelines here, and BBI is a time-bound process. I wonder how it's gonna fit into this. However, before we get into that, it's prudent that we get to know from you, in summary, is it that this ruling put together is not applicable, it's not appealable, or is appealable?
Okay, first of all, I think the first point to begin is, does the law gives the right of appeal? I'll say yes, the law gives the right of appeal. You have to prove quite a number of things. One, you have to prove that the appeals are necessary. You have to prove that there was misreading of the law. You also have to prove that if certain things are not heard and are not appealed, they'll affect other processes. Yes, this ruling is appealable because of quite a number of things. One, it is based mainly, if you look at it, the judges were not actually mentioning the law. They were mentioning how they think things should be. It was mostly based on their interpretation. For example, the Constitution does not say who a promoter is. Like, for example, it tells you to bring a popular initiative. It uses the word, so you have to be a citizen. Then it calls you a promoter. It does not exclude anybody. It is just an interpretation of the judges or of the court that a promoter should not be so and so, and it should be so and so.
Which again looks discriminatory.
Yes, and also so many people have looked at so many things. One, because you see, the courts even tried to give the impression that constitutional making process should not be a political process. But Nick, you look at constitution making everywhere, including even the one that we have, it was through a political process. It took this long because of disagreement between politicians. Yes, so you cannot actually rule, and you cannot, yes. And why can you say that this politician is ruled out and this politician is not ruled out? Because there's even the whole concept that, look at constitution making. If you look at the manner in which the court is saying who Wanjiku is, then it's not possible that Wanjiku can bring constitutional amendments, because he won't even have resources to. Because you look at, even the court's ruling was about providing copies. No enough copies were provided for Kenyans to read. A normal Wanjiku, if you understand that normal Wanjiku, in the name of, or let's say that we say a normal Wanjiku is now a hustler, can he really print those number of copies? Can he really take them to the county assemblies? Can he engage the county assemblies? So this, yes, and I agree with Gitonga, there are so many contradictions, or so many things that can actually be overturned. Because you look at even the practicality. And for example, the court even said that the referendum should not be a single question referendum. The BBI bill deals with more than 100 amendments. It's not possible to take to Kenyans 100 questions. You ask them that, yes, what do you say on expanding the executive? Is it a yes or no? What do you say on ombudsman in the...
It becomes an examination.
That's why it's said that it's good reading for people who are interested in academics. Because some of them, the practicality aspect of it, for some, is not possible. But yes, I also have a feeling that there are also other issues which they are also genuine about. about things like the limitation of boundaries and things to consider and all that. But you get to realize that, Nick, the main difficulty with, or the main issue with the BBI is that it went through many stages. There are certain things that were never intended to be the way they were. Like you'll realize if you read the first BBI bill, the constituencies, those 70 constituencies, they were actually not geographical.
Yes.
Meaning they were not going to take away the work of IBC. But through give and take, negotiations and all that, the one we ended up with was now through geographical, where it even mentioned Nairobi, how many constituencies, Murang'a, how many constituencies, Homa Bay, how many constituencies. And through that, the court felt that now you're taking the work of another constitutional commission, which now you've gone beyond your capacity and your power. Yes, to me, this is also the other thing that Kenyans also need to know. That there are certain processes that you might take to court. Court agrees with you, but court tells you it is in the public interest, we cannot reverse this or we cannot stop this. Constitutional making is one of those processes, because you cannot put, and let's even be honest, if you say that a popular initiative is supposed to begin with this person called Wanjiku, are we saying at any given point people are not supposed to debate, people are not supposed to enrich it, people are not supposed to see that, yes, this is how it can be? So, to me, most of them are appealable. Most of them, especially, the court looks at it in terms of, one, the process, and two, the content. I can say that, yes, there are certain things about the process that, yes, to me, you cannot actually, because let's even say about the presidency. And to me, I tend to think the whole thing with BBI is the issue of who is telling which story. And I think it's the story that has not been told correctly. That's why the court saw it the way they saw it. Like, for example, the court might not be aware that before the rallies, there was an engagement, public engagement. If, like, for example, we say that we are going to have a rally in Mombasa on Saturday, you'll realize that both on Thursday and Friday, there was public engagement.
The leadership of Mombasa, for example.
Yes, the leadership of Mombasa. Okay. So I tend to think the whole thing with BBI, which even got to the courts, they didn't know the whole story with it. Because even I can also tell you, for example, if you look at the whole story of handshake, depending on how it is told, to me, I don't see anything wrong with it. For example, it is the work of the president to unite the nation. He can come and say that, fine, I reached out to my brother Raila so that we unite this nation. While we were in the process of uniting this nation, we realized that there are laws that need to be amended.
And we did it
we did it, and we realized that we would have failed if we don't address some of these issues. What is wrong with us addressing these issues from our area? Well
put. I think Okello has tried to dissect it properly well. And Mr. Kitoko, do you think, let's assume it doesn't go the proponent's way, are there any other avenues, in your opinion, or other particular areas in the BBI report or the amendment bill that would be taken or can be taken and can now be dispensed with in Parliament in terms of legislation to fast track it? And looking at the time frames that are there, is it really possible?
Yeah, definitely. I think all of them can be taken to, they can go through the Parliament way, and then eventually go to the referendum, even amending the executive, and all the amendments, they can go through Parliament, and then but of course it will take definitely to take time because of say like
the process.
Yeah, the public participation and all that. So it's really the time factor is not in the favor of the proponents of BBI. Although they had tried in the amendments, they had tried to safeguard that on the time, because they had proposed that Article 89, I think 89C, that does not apply to
1 year before publication.
Yes, 1 year to the new constituencies. So in that they had safeguarded. So in fact, we can even do the delimitation of constituencies even as maybe a few months
to elections.
But now the problem here is that you need to register voters afresh. And it becomes too much for IBC to handle that, and then you are going into elections. But either way, I don't think, in my opinion, I don't think there will be any referendum. I don't think they will be able to overcome this hurdle of the limitation of. I don't see how, unless like Wakili says, he says in the public interest. They say, okay, the Court of Appeal might rule as much as this one was not adhered to, but in the public interest, let's have, let's continue. Okay, let's we'll kind of overlook this, that this is and then they could argue, even if IBC was going to do it, we are probably going to arrive at the same.
The same results.
Yes. So they might argue, they might say, okay, we will just let it go, because anyway the difference is the same.
But you say, in your opinion, you don't see a referendum coming before the next general election?
No, unless now, because that had of the limitation. That one, I don't know how they're gonna clear it. To me, that is the one. That is one that is difficult.
To surmount.
Yes, but the rest, I think they might be able. They will be able to go around that. But now, unless now the Court of Appeal now rules like Wakili says in public interest, I don't think there'll be in. I don't think there'll be in the referendum.
There won't be any referendum.
I don't think so.
And should we get to a point where we don't have any referendum, will you still have the feeling that this thing was properly done?
It definitely was not properly done. It was not properly done, and as Wakili says, initially, I don't think there was any intention actually of amending the constitution. I think this one it developed. It developed now.
Inside that shake.
It developed after they had discussion, and then they were like, yeah, but you could do this, we could do this. Instead of probably initially they were probably going to just maybe enact a few laws here in parliament, but then they realized, well, you might as well, let's amend the constitution, let's provide for a bigger executive, and then they were like, okay, when a state, why don't we also, people have been complaining about constituencies,
let's add that one.
Let's add that one as well.
To sweeten, just sweeten to the process.
Yes.
Well, like Gitonga says, it remains a very murky situation for this process called BBI. However, like the all conquer, it's possible that it could be overturned in other areas. However, it remains very, very, very challenging when it comes to now the limitation of boundaries, which is the prerogative of IEBC as per the Constitution. Let's wait and see what comes out of the courts. However, still in the courts, this very week, again, President Uhuru Kenyatta suffered again another humiliating and embarrassing moment constitutionally, having appointed leaders, heads of parastatals, chairpersons, and even executive chairpersons. All these that were done for 128 heads of parastatals were unconstitutional according to the same High Court. What is it that is happening here? I mean, as Uhuru's legal advisors just gone to sleep and they are not doing anything as far as this is concerned?
I don't think really Uhuru has suffered any defeat here, because one thing is Uhuru does, he ignores the courts. He doesn't really.
Is that contempt, a very strong contempt he's got?
But it's a fact, yeah, it's a fact. He does not pay much attention to the court orders, unfortunately. So even that ruling, I think well, they will probably appeal it, but it doesn't really bother him. You saw this week he went to launch Kenya Meat Commission.
Kenya Meat Commission in Lucky Summer.
Yes, and the High Court had ruled that it is an illegal. The handing over.
The two ministries would not exchange the roles. Yes. Where Minister of Agriculture would let Minister of Defense run KMC.
Yes, and he's not bothered about that. The court also ruled that he should appoint the judges. He has not appointed. The court also ruled that Miguna should be allowed back into the country. He has not been allowed.
So Uhuru Kenyatta is going down as one president who disregarded the courts entirely in his presidency.
He has. You remember they were also asked to open ABC servers. They refused to open. They did not allow.
So they don't care about court orders at all.
Definitely, this regime does not respect the courts. Does it?
Wakili, you are a practicing lawyer. You are in the fraternity of lawmaking and adjudication. What then does it portend for a country whose leadership is acting in total disregard and it's blatant impunity that is being exercised here? Because we can't be looking at one case to another, and it's becoming now a litany of reversed appointments. Just everything doesn't work in terms of these courts for Uhuru Kenyatta. Just what is the problem here?
Nick, I agree that yes, there's been a lot of disregard of court orders by the executive, which does not mean well for even his legacy. Maybe nothing might happen to him as a person, but it might cloud his legacy such that people might see him as this person who was never keen on respecting judicial independence and judicial processes, which I don't really think is a good thing for his legacy. But having said that, also there are also increasing concerns within even the legal circles whether there is a lot of judicialization of politics, where you begin to have this impression as if courts are keen on running this country. Courts are keen on, you make a move, courts want to tell you can't do this, you can't do this. And to be all honest with you, I have a feeling that our courts are also going so far, Nick, because to me you can't really be a president who you can't do. And once again, I still go back to the practicality of some of this. Like I saw the ruling about the appointment of those parastatal heads and all that. What the courts to me are saying is not really practical, that people should apply for those positions, we go through interviews and all these other things. I honestly don't think, and it is the same thing in virtually almost all the countries, even the developed nations, that as a president, you can have people who you think the same way, who you think are keen on helping you implement your agenda. And yes, within legal circles, there are people who believe courts should, and they are philosophers, not just only Kenyans, that courts should restrain themselves from engaging in matters politics. The other thing that also is important for Kenyans also to know, and I think that's why I'm saying it's connected with even this whole BPI process, that sometimes courts can come and say that the process is unconstitutional. But now, you can also not do anything about it as a citizen or as a person who went to court, because if you're also allowed to do it, then we will have a situation which now make things very difficult for everybody. For example, the courts have said that the parastatal amendments were unconstitutional. Let's say, as Nick, you were fired by Gitonga, who was a parastatal head, and now the courts have said that was unconstitutional. Can you now go to court and say, I was fired by somebody who was in office unconstitutional? Or let's say, I got a check that was signed by Gitonga because it was appointed by president in 2018. Can somebody now go to court and say, I received financing from a bank which was signed by somebody who was in office illegally? So that's where the courts can actually say that in as much as we find this unconstitutional, it is in the public interest that we cannot reverse this or we cannot make these actions illegal. Because if you do, then now you will be dealing with another situation that will be far-reaching. Like, for example, that's why even IBC had to appeal the ruling of the quorum. Because it means that somebody can go look at the violations that have been done. Somebody can go and say that there was no IBC. The people who did this election was a kangaroo association. If the court says that the IBC must have this for them to be called as IBC, then it means that now we want fresh elections in Musambweni, we want fresh elections in Matungu.
Yeah.
Yes, so some of these things, it's good to note that the court can find something unconstitutional, but they don't stop it from proceeding. Like the Court of Appeal can actually go and say that these 17 issues, some of them we find unconstitutional, but it is in the public interest that we still proceed with them. But yes, let me also say this lastly. I have a feeling, and I'm saying this with all honesty, some of these situations we ended up here by Uhuru and Raila refusing to listen. For example, which we even discussed in this show, whether it's possible to amend the BBI bill. If they could have agreed, because there was no law that was saying it could be amended. If they would have agreed such that it's amended and we say that what should be done by IBC, let's leave it to IBC.
Yeah.
Then it means that bill would still be where courts can actually say this is now no longer an issue at this particular point. But yes, the truth is they also refuse to listen at some point.
You've talked about referendum. We're just about to close the show. The courts again said no referendum. IBC cannot conduct any referendum. They actually put a closure to it. It was so funny to understand that you look at the rulings and you wonder whether this is supposed to be a vendetta or it's supposed to be a dispensation of justice. You guys cannot now run another any referendum because first of all there's no referendum law. As you complete in the next 1 minute.
Like Wakili says, the courts, the judges actually want to own, they really want to own the constitution. It's not like it's a Kenyan document. Now they want to own it, and they are the ones now to interpret it their own way. Saying that there is no referendum law, they say there is no referendum law, but it does not mean that the Constitution provides that there can be a referendum. It does not necessarily, the Constitution does not say that there has to be a referendum law. So you cannot say you cannot carry out the Constitution because there is no referendum law. And the Constitution provides that you can carry out a Constitution. And then what they said is like they put a permanent injunction on holding.
It's like a closure.
Yes, they're putting IBC out of work.
It's so funny. With or without referendum law, I think the Constitution provides for referendum, popular or parliamentary. And that alone is supposed to be talking about the basic structure of the Constitution. It's basically talking about a referendum.
Yes.
And you cannot deny the Constitution what it's providing for itself. And I think, in summary, it was just one of the very interesting times in our country in terms of what justice dispensation is all about. And lawyers will help us into this going forward. I think Kenya is also falling in love with courts. And people feel that, you can go and get any sort of injunction you want, and you can go and play your games with the courts, and the judges will just play to that. However, I think there's also a point to be taken home. This serial disrespect for the courts must stop. Because of time. So interesting, because of time. Perhaps we close the show, and as usual, we do our tradition where we check and see what captured your imagination over the week.
What did we have this week? I think I've been missing in action. I think this week, it's a contribution of just the BBI BBA ruling. Other than that, there was that shenanigan of the coronation of the House Speaker.
We just employed as a spokesperson from Mount Kenya.
But what they explained is the spokesman for the elders, you know. Okay, he was appointed by the elders to be their spokesman. But well, the elders are the ones who speak on behalf of the Mount Kenya people. So we are waiting to see what he will be speaking about on our behalf. But I don't think it doesn't. There isn't much to it. It's just shenanigans. Shenanigans. Today.
Just keeping the grapevine busy.
Yeah, has got no value politically or even socially.
Well, Okello, what captured your imagination all the week?
Yes, what captured my imagination, and I agree also, it was the coronation of Speaker Justin Muturi. First of all, I don't think there's anything wrong with it. But to me, what captured my imagination was some people tend to proceed in this country without real consultation. And they also don't think that it's important to get the public buy-in. You can't be my leader, you can't be my spokesman without consulting me. Have a feeling certain things should have started, and then there's a public buy-in where we say, so and so is our leader. It's our leader. If you remember, and this is my parting shot, that at independence, the colonialists wanted to hand over power to Jaramogi Oginga Odinga. Jaramogi Oginga Odinga told them, no, I won't take. Our leader is Jomo Kenyatta. Meaning there was some sort of consensus. I tend to think there should also have been.
That's where he blundered.
There should also have been consensus before appointing Justin Muturi.
That's what Jomo Kenyatta blundered.
No, Jaramogi. Yeah, they are paying for that heavily. Until to even now. And you see now what we even have a son now because of that single blunder.
Okay, well, for another day indeed. Yes, gentlemen and ladies who are watching this show, it's been wonderful having Mr. Gitonga Wadhanga around. He's a politician and he's somebody who's seasoned in politics and also a business person. Okello, thank you very much for even giving more insight and even bringing into fruition some of the speculations that we've always had around here. However, it is a reminder, a stark reminder to our leadership, a stark reminder to Kenyans that yes, our constitution is work in progress. Our constitution remains actually our founding element, our basic founding element as a nation. Anything we want to do with this constitution is permitted. However, it is also instructive to imagine and think that anything we do, much as we have the liberty to do it, must also be looked within these prisons of excellence, and also due diligence must be summoned. Otherwise, the very many years of struggle to this better constitution would count for nothing if it must just be another document that every person will be perusing through just to look for what to cause problems in the courts, in the political arena, and into our lives. As we proceed to the appeals court, let's see what's going to be dispensed there. However, it is instructive that Kenyans are finding reasons to go to the courts. And I believe it's a good practice for democracy. Let's protect our constitution. Let's give it life. Let's have it. It's our baby. We've got to nurture it. And I believe we are doing right that. Until we meet again next week, gentlemen, thank you very much. Next week again, if you are requested to come over, please do find time to come. For you, the viewer, it's been wonderful having you along. Thank you so much. Next week, another time like this.